Hi everybody, this video is about motions. Motions are documents that one attorney will file against another attorney, another law firm, another party to get them to do something or to try to win the case. So the biggest and most important motion that one side can make against the other is the summary judgment motion. And that means that the court is being asked to summarily decide judgment in favor of one side or the other. And the party that is bringing the summary judgment motion is trying to convince the judge that there are no issues of fact that need to be decided by the jury. In other words, a good example of this is where we bring a motion for summary judgment in favor of our client against the car that hit our car in the rear. Our driver, our plaintiff, our client was driving the car. They were stopped at a red light and they were struck in the rear by the defendant's car. In that situation, we should win the summary judgment motion because there are no questions of fact about how the accident happened. Now, sometimes the driver in the back, the defendant, will argue that something else happened. I've had them argue that our client backed up their car into them, which is usually a pretty hard argument to have, but listen, stranger things have happened, right? Or they will argue that our client was speeding and then came around them, cut them off, and then stopped short. And if that was true, then it wouldn't be entirely the car in the rear's fault. So there would be an issue of fact. But when we go to prove a case like that, we want to submit a certified copy of the police report, which has a statement from both of the drivers. Hopefully the rear driver is going to admit that they hit us in the rear. And usually we get our client's deposition testimony, and that says what happened, and that's good enough. That's like a sworn statement, like an affidavit. But if, for example, we didn't do the depositions yet and we want to prove that we should win the issue of liability, then we can get an affidavit from our client that says, yes, I was stopped at the red light for 15 seconds, 5 seconds, whatever it is, and then all of a sudden I got hit in the rear by the defendant. So that's one example of what they call summary judgment on the issue of liability. And the other example of this we have was in the case of Suarez. That's a medical malpractice case where the defendants have went out and received or got testimony, affidavits, affirmations. It's an affirmation when it comes from a doctor or a lawyer, because we're allowed to affirm the truth under the penalties of perjury. But if it's a non-doctor or a non-lawyer, it has to be an affidavit, and the affidavit has to be notarized, and then it can be something that is relied upon by the court as a sworn statement. But anyway, that Suarez case we got, that involved a situation of something called mesenteric ischemia, which had to do with a reduction in blood flow into our client's abdomen, and that caused a strangulation of the arteries into the abdomen, and that ended up causing our client to have a necrotic or a corroded or rotten intestines that had to be removed. But the other side had like 4 doctors, and their affidavits or affirmations, I should say, all said that the doctors did nothing wrong, and they wanted summary judgment on the issue of liability. And we had to fight that with our own affirmation and our own doctor's report that said, no, they should have done other things to prevent this condition from getting worse and the situation from elevating. And they failed to do that, so they were negligent in the way they handled our client. So those are two examples of the summary judgment motions, and we have to fight back against these and come up with creative arguments. You could have a slip and fall case where the defendant's expert says there's nothing wrong with the staircase or there's nothing wrong with the treads, and then we have to get an expert that says there is something wrong with the treads. And of course our experts are supposed to tell the truth, and hopefully they do tell the truth. And sometimes we'll have a situation where our expert says to us, I'm sorry, but there is nothing wrong with the staircase. And then, we'll have to try to explore other options, or, we'll accept that we're going to lose the case, and we tell that to the client. But that's the worst case scenario. We don't want to really have that situation. The other type of motions that are very common are the motions for discovery. The other side says that we owe them certain documents. They're not happy with the way our bill of particulars spells out what they did wrong, and they make a motion to dismiss our case because we're not responding to what they want. And so that's why it's very important that we, give them what they're entitled to. Obviously, we don't want to give them documents and things that they're not entitled to, but we want to be responsive to what they're asking us in the bill of particulars. And sometimes they go a little overboard and they ask too many detailed questions, or they ask for silly things. I just got a text from Jen, and the clients or the defendants were asking for pre-suit correspondence. I mean, I don't even know what that is. And they wanted copies of the no-fault file, which we will always give them, not copies, but an authorization to get the no-fault file. And oftentimes they're looking for items from a prior lawsuit, and we'll give them an authorization for that. And remember, their goal is they're going on a fishing expedition to find things that they can show that our client is lying about, or they had a pre-existing injury. So we have to be somewhat careful about what documents and information we give them. On the other hand, we want to know this stuff too. So whenever we give the other side authorizations, we should also be getting all of those records for ourselves. And that's something that we haven't been great at, and I want us to improve at. In other words, if the other side is asking for, 30 authorizations, we should be processing those as well for our firm to get that information. We have a case getting ready for trial where the client forgot about her prior back problems, and when she was asked in her deposition, did you ever have a prior back problem? She said no. And then the lawyer for the other side said, well, what about this MRI that you went to back 3 years ago at this facility on this date? And she said, oh, that wasn't me, which is a bad answer because everybody knows it was her. But she was not properly prepared to answer properly and say the truth. And now we're faced with a situation at trial where she is going to be asked that question, and it's going to be shown that she was not being truthful, and that hurts her credibility about other things at trial. Anyway, getting back to the motions, the other side, they make a motion to dismiss for failure to give certain documents, and the remedy for that is just to give them the documents they want and try to get them to stipulate to withdraw their motion instead of putting in opposition. And I mean, we can always put in the opposition, and if they won't stipulate to withdraw the motion, we have to put in the opposition, because if we fail to put in the opposition to that motion, the court could dismiss the case. So we always have to at least put in opposition. That way we've preserved our arguments, and if the case was ever to go up on appeal, we have preserved our right to appeal, because if you don't put in any arguments, any opposition, you don't preserve your right to appeal whatever decision was made. So that's a type of a motion. We sometimes make motions to file a late notice of claim. In other words, sometimes the client comes to us late and we file the notice of claim. It has to be done within 90 days, but if we fail to do that, we can sometimes get the court to agree to let us still file the notice of claim. If you don't file the notice of claim within 90 days, usually your case will be dismissed. So that's very important. We'll also file a motion on our own behalf to strike the defendant's answer. And we've been doing those more and more because the defendants are very slow, mostly on city cases, to put in their answer. And when they fail to put in their answer, they fail to complete their deposition, then we do this motion to strike their answer, which we threaten to do that, but we really just want them to do the deposition. So our strategy there is to file the motion, and then they ask for an adjournment, and we say, yes, we will give you an adjournment until the date, a week after you promised to do your deposition. And then that way it hangs over their head. That way the next time they won't cancel the deposition because they have this motion hanging over their head. And that often happens with the city cases because they are very lazy probably, and they don't want to do the depositions. The other motion that we do a lot is the default motion. And the default motion is the motion that is done when the defendant fails to put in their answer, right? We file the lawsuit, which is known as the summons and complaint, and after we file it, we must serve the summons and complaint upon the defendant within 120 days. So that's about 4 months. And we have to get an affidavit of service. We use an outside company called PM Legal. They used to be PM Legal. Now they're called Lexitas, to serve that summons and complaint personally on the defendant. And then they file the affidavit of service. And then, so when the defendant receives our summons and complaint, they are supposed to give that to a lawyer, give that to their insurance company, and get them to put in an answer within 30 days from the date they were served it. But that doesn't always happen for whatever reason. They don't always receive it. They say they didn't receive it. They don't know what it was for a lot of different reasons, and they fail to put in an answer. And what happens there is that we try to get them to put in the answer, because the last thing we want is to get a default judgment. We don't want a default judgment because it's very hard to collect any money when you have a default judgment. But we must do the motion within a year of the filing of the summons and complaint, or our case can get dismissed and we can get sued for legal malpractice. So we must do these certain things within certain time limits. And the motion is a little bit of a complicated motion. We have to get an affidavit from our client saying that they have a legitimate case. We have to submit the affidavit of service from that company, PM Legal. We have to also serve the defendant with the motion. And then the whole goal of the default motion is to get the defendant to wake up and put in an answer. And we just had that happen today on a case, Maria Vargas. We had sued the City of New York Housing Authority, NYCHA, and this other place called Grosvenor Houses, and NYCHA made a motion to dismiss because they said the accident never happened in their facility. And they were right. And we got a default judgment against that Grosvenor Houses. And when we went to enter the default, that woke them up and they asked to put in an answer. So we agreed to withdraw our default and allow them to put in an answer. Because the other alternative is that we would get the default motion, we would win it, and then the case would be set up for an inquest. And an inquest is like a miniature trial, but the defendant doesn't show up. And what happens is we just ask the judge for as much money as possible, and more often than not, they award it. But then it's a problem to actually try to execute that judgment and get the money. We hire like a sheriff or somebody to execute the judgment, but if the party doesn't have any money, or if they hide their money, we can't get it. So it's not the situation we want. We really want to wake up the defendant to do what they did in the Vargas case and ask us to withdraw our default and give them 30 days to put in an answer. That is the perfect result for that situation. So that's sort of a summary